Good evening, everybody. My name is Malika Sen, and on behalf of the editorial board of the NLS Business Law Review, I would like to welcome you all to this session. It's my absolute pleasure to introduce the guest speaker for this session, Professor Rahul Singh. Professor Rahul Singh is currently an associate professor of law and the director of the Institute of Competition Law and Economics at the National Law School of India University, Bangalore. He teaches competition law, law and economics, jurisprudence, and corporate law at NLS. As a visiting professor, he has lectured at Harvard Law School, University of California at Berkeley, University of Florida Levin College of Law, University of Oxford, and Deakin University, Australia, as well as the Indian Institute of Management at Bangalore. Professor Rahul Singh has been nominated by the Chief Justice of the Singapore Supreme Court to serve as a member of the governing board of the Asian Business Law Institute, Singapore Academy of Law. He is also a member of the advisory board of this journal, the NLS Business Law Review. In this session, Professor Singh will argue that a synthesis of law and economics and exclusive legal positivism provides a strong jurisprudential basis for understanding Indian business laws. He will do this by taking an example from company law, competition law, and Indian bankruptcy law to illustrate his point. I would now request Professor Rahul Singh to take over.
Okay, good evening, everybody. Thank you. Sorry about the echo. There is a technical issue because of which what I have done is to just let me set this right.
So we were able to hear you before,
Okay, apologies for that. I suppose it should be audible now.
Yes, so we have no issues with the audio now.
Okay, apologies. So let me begin this quickly. What I'll do is I'll do a share screen of one pager. And thank you very much, Malika, for that very kind introduction. I'm also very grateful to NLS Business Law Review for two things, actually. One is making sure that this is possible. Second is to both Vasu and Malika, I must say, your persistence is very admirable. Because as both of you know, initially I was not very keen about doing this, but nevertheless, both of you have brought me around to it. So I'm very grateful and I want to acknowledge that publicly. Right? Thank you very much. With that, let me do a share screen of one page on this talk. And as Malika rightly put it, the idea is to, I think right now what you can see is not the document which I want you to see. So just 1 second. Let's see. Yep. Okay, so you should be able to see this one pager, which is titled as the Holy Grail of Jurisprudence in Indian Corporate Competition and Insolvency Law. I understand this is what was also circulated to all of you. So you are familiar with the title as such, right? Now, what we are going to do is, as Malika rightly pointed out, that there is a claim or thesis statement here that I want to argue, which is essentially to suggest that we must take a synthesis of ELP here, which is exclusive legal positivism, and LNE here, which is law and economics, seriously. And I want to, right at the beginning, suggest that this is not some grandiose claim. This is, in fact, meant to be modest in the sense that the idea is not to suggest that in any particular manner, the jurisprudential school of exclusive legal positivism or law and economics, they are in any way superior to any other schools. The idea is to very modestly claim that they are a useful vantage point for the purposes of looking at corporate competition and insolvency laws. So this is the claim or thesis statement of the talk today. What I'm going to do is to look at 3 different cases. One from, let's say, corporate domain, another from Competition Act, and lastly from insolvency law domain and try and see whether this claim or thesis statement works for all of you or not. What we will do for the purposes of housekeeping is that, if you allow me first, maybe half an hour or 40 minutes or so to lay out my examples or test suites or use cases as I call them. After that, we can open it up for the purposes of questions. So I will take silence as acquiescence and move on very quickly to say that, the idea is to look at the synthesis of ELP, which is Exclusive Legal Positivism, and Law and Economics, which is LNE, seriously. Now, this is the model of framework, which is the first part of my presentation. So you can see on the one pager here. So this is the model of framework I'll use. In part A of this model of framework, I want to look at ELP, and part B, I want to look at Law and Economics. I'm also deliberately showing all of these through my cursor so that, for people who might want to listen to later, it could be useful. So let's begin with ELP, or Exclusive Legal Positivism, and I'll very quickly lay down the framework. Of course, all of these are not new. You should be able to pick up books on jurisprudence and read about what Exclusive Legal Positivism is, what Law and Economics is, excuse me. For my purposes, I only want to quickly suggest that, see, for the purposes of Exclusive Legal Positivism, I'm looking at people like Joseph Raz, who talk about what is called the source-based thesis, right? What does it mean? I mean, essentially, in terms of jargon, it goes something like this. People who believe in ELP or Exclusive Legal Positivism, they make a claim that all law is source-based, and anything which is not source-based cannot be law, right? But what does that mean? I mean, if we demystify it, essentially, what does it mean? Of course, see, no legal scholar has ever claimed that they are a formalist, so as to speak, right? But this comes quite close. What does that mean to be a formalist? Essentially, it means that, there are these statutes, let's say Companies Act 2013, right? Or Competition Act 2002, or Insolvency and Bankruptcy Code 2016, the three statutes which are of interest for us. Like demystified, people like Joseph Raj would say that, of course, you cannot ignore what the statute says, right? Why should this be important? Isn't this something which is very obvious as a statement, that if there is a statute which Parliament has passed, then how can anybody just go about ignoring them? Well, the moment we will see these cases, you will see how exactly the court goes about ignoring statutes which are passed by the Parliament. So keep that in mind. And this is just for the purposes of, I've done a very quick intro into what is the meaning of Exclusive Legal Positivism, and selectively, so as to speak, only for the purposes of my lecture. Of course, all of these schools of thought, they have a lot of nuances. They are quite complex, right? Now, to go back on to part B of this model of framework, which is Law and Economics. So there are only two which I have pointed out here, but some of you know, because I see many of your familiar friends from my classes earlier, so I can say that with confidence, that you will remember that I have not put deliberately Calabresi, because the examples which I am taking today, Calabresi might not be so pertinent. But nevertheless, having said that, for the purposes of those who are familiar with Calabresi, there are two law and economics scholars who are present here. One is Posner, who talks about wealth maximization or caloric sufficiency. What does that mean? Demystified, that means that resources must lie in the hands of those people who value it the most, right? In other words, what does it mean? That essentially, if you're looking at any kind of decision making, there'll always be some winners and some losers of that decision making. The idea is to suggest that, well, winners must win enough in order to compensate the losers, right? Of course, you don't need to do an actual compensation. A possibility of compensation is considered sufficient for the purposes of Posner, right? Then there is Ronald Coase, who talks about transaction cost. Essentially, what does it mean for some of you who might have a background in physics? This is the friction equivalent in physics, right? Which is, you see, because let's say there is friction, there is also something which is called motion, right? Otherwise, if you have any particular body in absence of friction, they will never stop moving, right? Or they will just stay wherever they are, right? Something similar happens in legal context. So Ronald Coase talks about transaction cost. This is the cost of entering into a transaction, whereby all he meant was that, well, resources are very scarce. We must be careful about employing resources, right? How do we connect the two? This idea of exclusive legal positivism and let's say law and economics, which is part A and B on my model here. So you can see from Cose's perspective, it would be very simply this. If Parliament has already passed a statute, right? If we start reimagining, let's say if the judiciary starts reimagining what would be the best thing to do for the society, that might be just waste of resources, right? Particularly in the light of, let's say, a statute which is reasonably clear. Of course, we know that, that's a tall order. What is the meaning of a reasonably clear statute, right? We'll see very quickly the moment I take these use cases and test suites, the moment I take these use cases or test suites, you will see what does it mean to say that, even though Parliament has passed a statute, the judiciary might not necessarily take it very seriously. And that itself might create some sort of transaction cost, so as to speak, right? So it's very deliberate on my part to sort of lay down this model or framework very quickly because, I'm sure some of you would be familiar that these schools of thoughts are quite complex and deep. They require a broader discussion, but that might not be relevant for our purposes. And therefore, with this very basic sort of background on what is the meaning of ELP and law and economics, my hope is that as I'll move on to part 2, which is on use cases and test suites, it will be clearer in terms of what do I really mean, right? So in fact, what I'll do is to spend a little more time on, let's say, the first use case or test suite, first example, to ensure that all of us are on the same page, and the rest of the 2 I might do relatively quicker to ensure that we also have sufficient time to have a discussion. With that, I'm just going to quickly move forward, look at these use cases or test suites, and in fact start with the corporate law example and deliberately taking a very recent sort of a Supreme Court of India decision, which came about on 27th of July, 2020. Right? I'll of course lay down the basic facts of these cases to make sure that we are all on the same page. So here, this is Shailendra Swaroop. I've only put the last name of the case, which is Swaroop. So let's look at this Swaroop case. And what is this case about? Quite interestingly, this case is about director's liability, right? Now, for anybody with a basic notion of, let's say, familiarity or even interest with corporate law, I'm very sure that, you would be very interested to know what is it that Supreme Court has spoken about director's liability, right? So let me lay out some parts of material facts over here. So quite interestingly, by the way, this case involves a Supreme Court advocate, by the way. So Mr. Swaroop apparently is a Supreme Court of India's, practicing counsel, apparently, advocate on record, right? What happens with him? Well, he is a director in one of these companies or corporate entities, right? Now, there is some kind of a proceeding against this corporate entity about the infringement of the Foreign Exchange Regulation Act 1973, the old one, not the new one, which is FEMA, the Foreign Exchange Management Act. As you know, in Indian context, these cases can have a very long life, right? So this case involves some kind of, infringement or alleged infringement of this FERA law. But why? Only because he was a director in this corporate entity, right? Now, what happens is this. So his argument in the Supreme Court of India, of course, as you know, with these kind of cases, and particularly because they spend so much time in so many forums, there is a long history of what happens in the tribunal, what happens in the High Court. But, I will start from the reverse, which is, more interesting for me because as it is, as you know, when we look at these cases in terms of use cases or test suites, we are largely interested in the so-called appellate jurisdiction because, as you know, as the saying goes, the Supreme Court of India is final, even though it is not infallible, right? And many of these cases, like, let's say, director's liability, you might not see what might happen in another context, by which I mean is you might not have a review petition being filed, or you might not have a curative petition being filed. And therefore, Supreme Court does turn out to be the final court in these contexts. And therefore, what is of interest for the purposes of our talk is the Supreme Court of India decision on 27 July 2020. It's fresh off the pan in that sense, right? And let's look at what is it that Supreme Court is doing. So Supreme Court ultimately says, well, we have looked at these material facts and all. Sorry, is there some question or is there some noise? Okay. All right. So I'm just going to ignore that because I didn't hear what you said. So So let's move on and just think about the Supreme Court decision in Swaroop case. And ultimately they say that, you see, because the director here is a part-time director, non-executive director, and therefore the question of liability under FERA does not arise. This is what Supreme Court of India says. And you see, I mean, they look at, the FERA legislation, they look at the statute, and therefore accordingly they go about interpreting. And this is the part which I want to do on detail. For rest of you, if you're interested, you should look at this page 28, para 25. I'm going to actually put up that part of the judgment on the screen to make sure all of us are on the same page. And to remind you, I'll do this Swaroop case slightly more in detail compared to the next two examples, because you will see what I'm trying to suggest over here just from Swaroop. So let's see Swaroop. I'm going to stop share and put the other document up. All right, so you have this Swaroop case. So this is, now you can see Swaroop. So they're just quoting from FERA 1973. What I have done is to help all of you, I have put these annotations. Everything in red is my annotation. Everything which is highlighted is my highlight. So this is not what Supreme Court of India has done. But nevertheless, just to be on the same page. So they are quoting the section 68 of FERA 1973 to talk about the offenses by companies, right? And this is what they do. They say, see, we have looked at clause 1, which reads, where a person committing a contravention of any of the provisions of this act, or any rule, direction, or order made there is a company, every person who at the time of contravention was committed was in charge of and was responsible to the company. So all we need to do is to read until here, because you see what Supreme Court of India is doing. They are saying, look at this director. This director is a part-time director. And in a sense, I suppose for Indian Supreme Court, it's obvious that the director here is part-time, because they know that this director is an advocate on record at the Supreme Court of India. And considering that the advocate is a practicing advocate, it's but natural that the director must be a part-time director, can't be a full-time executive director, right? So in that sense, Supreme Court finds this to be a slightly easier or slightly straightforward kind of a fact situation, right? So they say, for instance, see, we have looked at clause 1, and it says, unless you are in charge of and responsible to, where is the question of, imposing any kind of liability? Now, this is what Supreme Court does, frankly, by the way. What they don't do, interestingly, is to look at clause 2 of the same provision. Very interesting. Which also starts with what is called a non-obstante sort of phrase, which talks about notwithstanding anything contained in subsection 1. Now, anybody with basic familiarity in law would know that if a provision starts with notwithstanding, it should indicate that it is non-obstante, which means that clause 1 is being overridden by clause 2. And then, as you know, and this kind of provision is very common in Indian law. If you pick up any statute, by the way, this is just one example. And very deliberately, I put this up on the screen because many of you might be familiar. This is such a common provision that if you pick up any sort of enactment, whether it is Environmental Protection Act or Competition Act, you will see copy paste or, Command C, Command V kind of provision, which will say something like offenses by the companies, right? It's a very short aspect of Swaroop that I'm interested in over here. I'm only talking about the aspect where Supreme Court of India is concerned about a director's liability. They are looking at a provision like Section 68 of FERA 1973, and they are looking at a material fact whereby they say, we understand that this person who is before us, he is a part-time non-executive director. So where is the question of this person being in charge of and responsible to, right? Of course, there is a certain sense in which, insofar as clause 1 is concerned, one can argue that the Supreme Court looked at without his knowledge or due diligence, which is part of clause 1, and they are not unfamiliar or ignorant of diligence. So they're quite okay, or Supreme Court of India is quite concerned. They are familiar with clause 1, and I've just highlighted this. they don't really look at clause 2 at all. And you will see there are 2 points in clause 2, and this is again a very standard sort of a template provision in Indian laws, right? Again, whether you pick up, let's say, Environmental Protection Act or SEBI Act or Competition Act, you will find something similar which is being written over. So first part would be non-obstante, and the second part also will say that it is consent, connivance, or attributable to any neglect, which is a very low threshold for people. A negligence-based standard is a very low threshold, right? But here, what the law does is there is something called consent, connivance, or negligence-based test. So it's not about mens rea, which would be intention, which is a very high threshold. This is relatively lower threshold, talking about consent, connivance, or neglect. You will also see that it's the idea of consent, connivance, or neglect is not dependent on whether you were in charge of or you were responsible to the company, right? So in that sense, the clause 1 is very different from the manner in which clause 2 is drafted. What is the point that I'm trying to suggest over here? And this is the only part which I want you to appreciate from the judgment. Of course, you're welcome to look at this judgment on your own. I have put the date of the Supreme Court of India judgment. I'll also mention the bench strength is 2-judge bench, and it's Bhushan and Reddy, judges of the Supreme Court of India. So 2-judge bench is looking at this. With that, I'm going to stop this screen share, go back to my 1-pager, because this sort of fulfills the kind of thoughts that I had in mind, right? Now let's go back to my 1-pager, and I'll do a screen share of that 1-pager and go back to the scheme that I have for my. What did I show to you? I showed to you this para 28, page 25 from this judgment. That's all I did. And this is from the Supreme Court of India version. So if you are using something else, let's say Supreme Court cases or any other, privately published or distributed judgment, you will have to look for a different kind of page number and different kind of paragraph number. This is just straight from the Supreme Court of India website, right? So what is the point over here? In Sarup, what is happening? To go back to my model of framework, right? Now, if we use this ELP-based of idea, which is Raj, source-based thesis, right? What's happening? The clause 2 of offenses by companies is being ignored, right? Now, what gives the legitimacy or what gives the authority to the Supreme Court judges to ignore, let's say, a particular clause of the statute, right? Now, of course, some of you might be wondering, but how can this happen? Didn't the lawyer argue? Well, lawyers in these cases are pretty, they're celebrities. They're celebrated lawyers. For instance, for the director here, I think it's Mr. C.A. Sundaram, the senior counsel who is representing him. For the government, it's the additional solicitor general who is representing the union or government's interest, right? State's interest. But nevertheless, you see, so neither of them, so whoever's, let's say, one can make a claim. Whose duty is it to make an argument based on clause 2? So I don't want to get into that debate because that's a Bar Council of India professional ethics question. But regardless of whichever lawyer had that duty, the Supreme Court of India judgment does not really deal with what is the implication of clause 2. What does that mean, by the way? To just again demystify this, what I am arguing is not that the outcome here is somehow predetermined, mind you. I'm not saying that had Supreme Court looked at clause 2 of the provision which I just showed to you, then the director will be liable under that provision. That's not the idea, right? In law, we are agnostic, at least in terms of methodology. We are agnostic about the outcome. What are we concerned about is the process, right? Which means that the Supreme Court of India must have or should have, ought to have looked at, analyzed the clause 2 of this provision as well, and then interpreted and figured out whatever that might mean in terms of material facts. So mind you, this is not to suggest that, the argument somehow, if the clause 2 of provision had been noticed by the Supreme Court of India, the argument is not so much as to say that Sarup would be liable for director's liability. That's not what I'm making a claim as. To go back, I'm just making a methodological claim that we must take a synthesis of ELP and law and economics seriously, right? In terms of law and economics, what does it mean? Well, if you even ignore the statute, I mean, it creates transaction cost in one sense, right? In our next case, we don't really know what is it that we should do in front of the Supreme Court. It creates transaction cost for the purposes of where exactly should lawyers or stakeholders in this particular domain must put their resources as, right? And therefore, that's my quick point in terms of how exactly ELP and law and economics are involved over here. I do understand that the point may be too quick, and therefore, if there are questions at the end, I will explain all of these all over again. But for the time being, in order to make sure that I'm able to do the use cases or test suites for other enactments as well, let's move on quickly because it's already 5:30. I'm mindful of time. I have 2 more examples to take. And, let me make these arguments as clearly as possible and then maybe invite you to pose questions, right? In terms of Competition Act 2002, I'm taking a relatively straightforward sort of a precedent. Again, Excel crop care case, which is a Supreme Court of India precedent. Some of you might be familiar, but for those of you who are not, see, in terms of looking at the penalty under Competition Act 2002, Section 27 of the Competition Act uses the term turnover. So the penalty is just based upon the idea of turnover. It talks about up to 10% of the turnover, right? Now, this is one case which goes all the way to Supreme Court. And, I'm deliberately not mentioning so many of these facts over here because they're not very pertinent, even though they might be material in the context of the case. They are not pertinent for my purposes, which is to prove my claim, right? What Supreme Court does here in Excel crop case, it reads this word called relevant, which doesn't occur in the statute, right? And only to that extent, I'm, suggesting that you see, even in terms of looking at cases like Excel crop care, again, the methodologies of ELP and LNE, they are very pertinent or they are useful because they will ask us to look at why is it that Supreme Court was so concerned about putting forward a qualifier called relevant just before the turnover in terms of penalty in Competition Act. Now, again, to re-emphasize the point, I'm not making an argument related to an outcome over here, right? Which is, let's say, Supreme Court of India, one can say that, one can make a consequentialist argument that it's a good idea that Supreme Court has somehow read the word relevant for the purposes of determining penalty in terms of Section 27 of Competition Act. Or it might be a bad idea, right? So regardless of whichever side of the divide you find yourself in, my point is slightly more limited. That, regardless of whichever side of the divide you are in, both exclusive legal positivism and law and economics can give you a framework or a methodology to understand what's going on in these cases, right? Like, what does it mean? An exclusive legal positivist will say, where exactly the Supreme Court of India gets this authority to introduce a word which Parliament has not put in a statute? Is there a precedent over here, right? Like, has Supreme Court ever articulated that, we have any kind of authority whereby we can read these words which don't otherwise occur in the statute? Or does the Constitution itself says that, Supreme Court of India can introduce some new words in the statute? Of course, if we look at Article 141, which is, very basic sort of idea in terms of looking at constitutional law, it only talks about law declared by the Supreme Court. It does not talk about law created by the Supreme Court. So an obvious question from ELP or exclusive legal positivism perspective which arises is that the moment Supreme Court of India introduces this word relevant, are they creating a statute or are they merely interpreting a statute, right? Now, if we assume that they are creating, it has transaction cost, right? Because we don't know, for instance, to go back to Coase, who talks about this transaction cost idea, we don't know what are these cases where Supreme Court of India picks and chooses in order to create some new kind of entitlement, right? One can also possibly introduce Posner over here, right? Which is when Supreme Court of India introduces these words like relevant in a statute, is that somehow, in accordance with wealth maximization, or is it caloric sufficient, right? Like when people, if left to themselves, if they bargain with each other, Like the society, is it, or winners of this particular kind of bargain, are they winning enough in order to compensate the losers, right? And these are the kind of questions one will raise if one wants to utilize synthesis or amalgamation of exclusive legal positivism and law and economics. So again, very quickly, this was my Competition Act 2002 example. Again, in the interest of time, I want to move on to my third use case or test suite to make sure that we are able to do this on time, leaving aside some quality time for your questions as well. For IBC 2016, which is Insolvency and Bankruptcy Code, the case that I have taken as a steel is fairly popular case, actually. I'm sure even if you have not read the case, because it's a fairly long judgment, you must have heard about this judgment somehow in the public domain, right? So let's look at SR Steel, which Supreme Court of India decided on 15th of November 2019. And there are two broad parts to this judgment. By and large, most people have positive things as a commentator to say about SR Steel. But I am somebody who believes that, if you utilize this methodology of exclusive legal positivism and law economics, the judgment is not as straightforward as it seems, right? What are these two broad parts? In terms of looking at creditors committee or committee of creditors, what the judgment does, and some of you might have heard this, because this is quite popular in public domain. They found that, creditors committee has a primacy, in the sense that, the NCLT or the NCLAT, which is, these the tribunals which are involved in the domain of IBC, they shouldn't be second guessing what committee of creditors says. And in order to get there, they not only just rely upon the statute, but also statutory instruments. And I want to explain what do I mean by this, because statute is the legislation which Parliament passes. Statutory instrument is the delegated legislation, right? The regulations, right? In this case, they rely upon this IBBI, the Insolvency and Bankruptcy Board of India regulations, to get to the idea that creditors committee must have some kind of premise. So far, so good. It looks like, Supreme Court of India is just relying upon the statute and statutory instruments. So what could be a problem? Because somebody who argues for taking statute seriously, like for the purposes of exclusive legal positivism, what can I really say in terms of what is wrong with the judgment, right? But there is another part of the judgment, because the judgment is very long, so I'm just dividing into two broad parts. They look at the introduction of the term mandatory, and they say that, the provision of the statute which talks about mandatorily finishing the process within 330 days, they say that part of the provision is unconstitutional. And you can see what's happening, So the question really is this, what gives the Supreme Court of India an authority to declare something unconstitutional? Of course, the answer would be the Constitution of India, right? But what part of Constitution of India? One could think of, let's say, fundamental rights kind of a violation or infringement, and one can say that somehow, the fundamental rights chapter of Constitution of India is being violated, and therefore it would be unconstitutional. But that's not what the Supreme Court does. So therefore, we can rule out the possibility of looking at fundamental rights chapter. Then the other aspect would be maybe legislative competence. If Parliament does something which, it's not competent to do, then it's unconstitutional. But again, that's not something which Supreme Court of India does, right? What do? They talk about this, this doctrine, which of course, I won't get into a lot of details because that will require a lot of explanation. But there is something called doctrine of manifest arbitrariness, right? Of course, people in constitutional law, they are familiar with the basic structure doctrine, but that's for the purposes of looking at whether a statute somehow fulfills the idea of basic structure or not. What has happened over a period of last few years in Indian, let's say, legal domain, there are two broad themes that I see as somebody who is interested in jurisprudence. In the context of constitutional law or public law scholarship, what's going on is, because since basic structure doctrine itself is very ambiguous, they talk something about what is called constitutional morality, right? So in a lot of these public domain or public law domain contexts, the Supreme Court of India strikes down legislations or talks about certain kind of executive action on the basis of what could be called as constitutional morality. The counterpart of that constitutional morality in private law domain, to my mind, looking at, let's say, enactments like IBC, and here is one example, SR Steel, the counterpart of that constitutional morality is this doctrine of manifest arbitrariness. Of course, we don't know the full contours of this doctrine because there are only 2 Supreme Court judges who have used this doctrine until now. But one of them used it while sitting in the same bench as the other one. And therefore, we don't fully understand the outer contours or boundaries of the doctrine of manifest arbitrariness. But nevertheless, that's not something which is pertinent for my purposes here. The only point I'm trying to make over here is that they use this idea of manifest arbitrariness doctrine, right? But that's not a statutory doctrine. That's not a constitution. It does not really appear as in the text of the Constitution. So to go back to our ELP model, or maybe a more sort of a formalistic model, people like Joseph Raz, and I'm just showing this to you on this one pager as well, they'll ask, what is the source of this, right? A sources-based thesis. Now, one small point I'll make over here, because you have seen now 3 examples from corporate law, Sarup example, from competition law, Excel crop example, IBC, SR Steel example. I don't want you to have this sense that by sources, we only mean statutes. We don't. It could be precedents as well, right? But then the precedent also have to have some kind of coherence, right? Which is, a 2-judge bench should be bound by what a 5-judge bench said. Or maybe a 5-judge bench should be bound by what Keshwan Bharati doctrine said. But where do we get this idea that let's say a smaller bench is somehow bound by the larger bench? That again is some Supreme Court decision, right? Which is, Daudi Bohra as a precedent. So regardless of, whatever maybe the sources of this, the idea is this, to suggest to you that when we look at the term mandatory under IBC, shouldn't we ask questions related to what is the source of this, right? To utilize the exclusive legal positivism model. Why should we do that? Because if we don't have coherence in the manner in which, let's say, jurisprudence of corporate law is developing, it will have transaction costs, to go back to course. It will also have some kind of adverse impact upon efficiency, because we don't know in a hypothetical sort of bargaining situation whether the winners of this kind of decision, are they in a position to compensate the losers of this decision? So again, at the risk of repetition, I'm saying that the idea is not to judge the outcome in these cases, but the idea is to look at the methodology which is being employed in each of these cases. To repeat, we are looking at from corporate law Sarup kind of example, a director's liability example. In a competition act context, we are looking at Excel crop kind of example, which is about penalty. In IBC 2016 context, we are looking at SR Steel kind of example. Now, what is my conclusion? Because I have very quickly sort of gone back and told you what are the 3 cases that we have looked at. It's a relatively modest claim, by the way, because I get sometimes quite perturbed that because they have never, many people, unfortunately, they in law school, they don't hear of either exclusive legal positivism or law and economics. So they start getting perturbed that has their entire legal education been a waste. And therefore, because of that, I'll mention that the argument or the claim is relatively modest, which is to say that both exclusive legal positivism and law and economics, they just provide an interesting vantage point. This is not to make a claim that somehow they are superior to, for instance, whatever else you are doing, whatever maybe your vantage point to look at these laws, right? So the idea is not to make a claim that they are somehow superior. The idea is to just say that they are interesting vantage point. And these 3 test suites or use cases that I have taken right now was hopefully useful. If they were useful, my only point is to suggest that, we must take a synthesis of exclusive legal positivism and law and economics seriously. Let me end over there. It's 5:44. I think we have done okay on time. And therefore, let's actually now look at some questions. Look at the chat window right now to see if anybody has any question. Right?
Sir.
Right, please go ahead.
Sir, may I retaliate you?
Retaliate? I'm not fighting with you. But
no, sir, I'm not fighting, but I have a few points to keep here.
Sure.
If you could share your screen, please.
Sure. I will share my screen. No problem.
So the way you said that exclusive legal positivists or hard positivists, they claim that there should be a source-based thesis. And recently, the Swiss Ribbon case, the Supreme Court has clearly said that in the economic legislation, we won't delve into much whether the legislation is feasible or not. This should be given a trial and error should be given a trial that since this is an economic legislation, we will be giving the government of the day to try whether this legislation will be useful or not. So anyhow, the Supreme Court is allowing the government, and by the mandate of Article 141, the legislation is getting the base there. Further, you were saying how this word relevant has been introduced. So since this is economic legislation, so the government, so the Supreme Court is allowing the parliament or the government to take some chances so that they could do the some trial with this respect to this area of competition. So I believe, and further you said that manifest arbitrariness doctrine does not have any source of origin, but this doctrine has its origin since from the EP Royappa case, and it is being developed in number of cases. Though Supreme Court differed for a number of years from McDowell case of 1996, but that was corrected by Justice Nariman in the case of Sahabano.
Sure. Okay, so let me actually respond very quickly over here. So I'll start with your relevant turnover example, which is, so who has introduced the term relevant in section 27? Not the parliament, by the way.
But the Supreme Court has done so as to say, the Supreme
okay,
Court
I think you will have to let me respond, by the way. It's not because that's not really either. So if you have not finished your response, please go ahead. I'll listen to you carefully. So but if you don't allow me to respond, that's equally unfair, right?
I'm sorry, sir.
No, please go ahead. I don't have a problem in you speaking. I'm just saying that, only one person can speak.
I was saying that the Supreme Court might have read down this provision so as to save the whole act.
Well, so you are speculating now on Excel crop care, right? So they have not used the idea of reading down. Their reasoning is slightly different, but you see, that's not pertinent for my purposes. So the first two parts of your statement are mutually incoherent, by the way. The first part you said was that, you see, when it comes to economic legislation, the Supreme Court has said that they will allow some kind of deference to the parliament, right? This is the first part. And this is Justice Nariman himself, in several cases, he has said the legislature must be allowed to play in the joints. I'm very familiar with this idea, the doctrine that you're mentioning. But you see, it's the way you are interpreting this is incoherent. And I'll tell you how. If you say that we will defer to what Parliament has written down in the statute, then that would mean that Supreme Court of India should not be introducing the term relevant when it comes to penalty in section 27, because Parliament has not introduced this term relevant. Parliament has only said turnover, right? So in that sense, the first and second part of what you have just mentioned, they don't stand in a coherent manner. The third part, so I will invite, by the way, Vasu to respond. I'll tell you why, because he has a better hold over, the trajectory that this idea of manifest arbitrariness doctrine has taken. But I'll only quickly say that, you see, so you said that, Justice Nariman cites Saira Bano for the purposes of MAD doctrine, right? But Saira Bano has multiple decisions. And if you look at, what is the ratio of that decision, that becomes quite difficult in terms of the theory of ratio. Of course, one can make a claim that whatever Justice Nariman says is the ratio of the judgment. But you see, if you go back to the basic ideas on what is the ratio of a judgment, the moment there are multiple judges speaking, then you look at the lowest common denominator, right, where everybody agrees. If other judges don't agree with him on manifest arbitrary,
Royappa to just strike down a subordinate legislation and not a legislation, and it was only first time in Shaira Bano when this doctrine was originated or created by Justice Nariman so as to strike down legislations, and only post that plenary legislations or plenary legislations have been used.
Right.
So to say that manifest arbitrariness doctrine is something that is being used since Eva Eureka, or to say that it's an old doctrine. It's a very new doctrine in terms of it being used to strike down plenary legislations.
Right.
Hello, sir. My name is Aditya. If I may add,
Aditya, before you speak, I think there's Prabhakar whose hand is up for quite some time. So let us give him a chance. I don't see your hand up. So Prabhakar, please go ahead.
Good evening, sir. Am I audible?
Yeah, you are. Please go ahead.
Yes. So, sir, before turning to my question, I just want to respond to the discussion we had. So, manifest arbitrariness, as the person concerned mentioned, I think the parliament enjoys sort of democratic legitimacy. So, if the court is using manifest arbitrariness as a sword to strike down legislation passed by the parliament, which has the democratic legitimacy and not some rule-making authority which does not have the legitimacy, and of course administrative law with notice and comment procedure and many other procedure. So the kind of revolution that has taken place from McDowell's case to Shaira Bano, where this MAD doctrine is used to strike down legislation, I mean from plenary legislation to the legislation passed by the parliament, is something unanchored in constitutional law and need to be questioned. So I disagree on him on that point. I don't know what's his point of view, but let me steer back to my question. So, yes, sir.
Sure,
So, sir,
please go ahead.
As you have taken 3 examples, and in 2 of them, the court has introduced 2 terms. Like one is relevant in SR, and the other is mandatory just the opposite, mandatory in SR and relevant in Excel Corp. Do you think this sort of judicial decision making is less anchored in the synthesis of ELP and the authority of law, what Joseph Law proposes, and is much more of common law, where the court is creating law instead of interpreting it? So I think this sort of aligns with your thesis also. But do you agree with this justification, what I'm proposing? Like even like taking criminal statutes like 304A, where medical negligence, where the statute says negligent, but the court adds the word gross. So there is one standard for gross negligence for medical negligence, and there is another standard for negligence for different professions. So do you think this kind of judicial decision making of adding words to the statutory text is less anchored in our like a system which is like not based on common law, or of course like we inherited some part of common law, but is unjustifiable in the context of your thesis, ELP and the authority of the law?
Right, thanks, Prabhakar. So that seems interesting, but let me actually take a step forward. I don't disagree with the analysis that you are undertaking here. I will say that it's not just unanchored. It has transaction costs for the society, right? Which is, let's say, for people who are quite moored or anchored in, to use your term, in exclusive legal positivism, what do they talk about? That you see, the moment Parliament has passed a legislation, what is the idea behind passing that legislation? There are, of course, debates around it, right? As a society, we have found a modus vivendi, so as to speak, right? Although we disagree with each other, but somehow, we have to find a way to keep moving forward, right? Now, having found a modus vivendi in a statute, if Supreme Court of India or any Supreme Court or any court starts relooking at what are the kind of words which must be used in the statute, then that's also a breach of that kind of a covenant or a compact between the citizens of the country, right? So I'm not just making a claim because though I do agree, I don't disagree with the thoughts that you have mentioned. I'm saying that, I'm taking a slightly step ahead in terms of law and economics to suggest that, this has costs for the society, which may seem slightly consequentialist.
Right, sir. Right. And sir, if I may just ask my last question. So suppose there is a precedent, and of course, like there is a lot of inefficient precedents which are not anchored in the ELP or either of these judicial decision making, which you're sort of proposing. What should be the way forward for the judges? So suppose if there is a precedent, corporate law precedent, which relies on complete justice approach or which relies on realist school, but it is itself a precedent, so it itself is authority of law. So if a dispute comes around, how should a future judge apply the synthesis of ELP and exclusive legal positivism in law and economics to analyze that precedent, because he cannot sidetrack it, suppose it is right. So
okay, now that's a very good and very interesting question, Prabhakar, because I'll tell you why. Because you see, let me ask you a counter question. Now, in terms of just looking at the Constitution of India, where do we get this idea that judges can sit in these panels of 2 and 3 judges and start declaring what the law is?
the Constitution doesn't say, it's the Supreme Court
Doesn't
rules.
say. So it's the rules, right? So
Yeah.
if you go purely by the Constitution, this is not what was envisioned by the framers of the Constitution. That judges, by just sitting in a panel of 2 or 3, will start declaring, some of these grandiose ideas about what is the meaning of director's liability, or what is the meaning of penalty in competition act, or what is the idea behind having insolvency and bankruptcy code. But unfortunately, that's the situation that we are in. Since you have asked me for a sort of a law reform question, so therefore the solution is much harder, right? Which is to maybe go back to the Constitution, take a hard look, and try and see whether the manner of decision making should change, which is to maybe have a constitution bench or 5 judges looking at each of these, and trying to find out, what is the precedent that would be most appropriate for the purposes of reading a statute, or reading even the Constitution or the text of the Constitution. But that's slightly, it's not so much related to what I'm trying to make a point over here, because I'm taking all of those as a given. I'm assuming that, Supreme Court of India will function in the same panel of 2 or 3 judges that it's functioning as. And I'm suggesting that, for all of us who are interested in corporate law, the vantage point of a synthesis between ELP and law economics could be helpful. That's all.
Yes, sir. Yes, I understand.
But thanks, Prabhakar. I think both great questions. Can we move on to Udita, whose hand is up? So, Udita Singh.
Good evening, sir. I have a question regarding the synthesis you were talking. How can we relate the synthesis to the rules of interpretation, be it judicial lawmaking, be it literal interpretation or purposive interpretation? Like in few cases, the 3 examples you mentioned, somewhere I feel that there is judicial lawmaking where the judges have created the law, but somewhere it is also the literal interpretation, like looking at the committee of creditors point. And in some other points, there is also purposive construction as a rule of interpretation. So how do we, when we are reading the 2 approaches, how do we read it along with the interpretation, the rules of interpretation?
Sure. Okay, thank you. So of course, some of my students would be very familiar because this is a very long topic, but nevertheless, let me summarize this, right? So your concern is the rules of interpretation. Now you see, of course, we talk about, the textbooks talk about literal interpretation, purposive interpretation, mischief rule, all sorts of things, right? Ultimately, if you look at what is it that the courts do, all of them essentially, they are trying to find some kind of synthesis between the text and the context, right? In that sense, they all converge to the point of, the courts are supposed to look at the text as well as the context of the legislation. In that sense, you see, these are not very discrete rules. By discrete, I mean separate rules, right? They are not separate rules of interpretation that sometimes we will do literal, sometimes we will do purposive, sometimes we will do, let's say, mischief, or sometimes we will employ this rule against absurdity. That's not really a good way to look at the idea of interpretation. In fact, most scholars who work in the field of interpretation of statute, the modern trend is to look at the idea of convergence. What is it that judges are doing and what is it that they are supposed to do? Like, none of the rules of interpretation will say, that you can just ignore whatever the statute says. Right? Where does the law and economics bit comes? Because see, if you're not ignoring the statute, then ELP is automatically satisfied as a judge. That is, right? Where does law and economics bit comes in? Within the, let's say, the play in the joints, right? Within the framework which the statute gives you, is there any kind of economic consequences that you as a judge should be concerned about, right? And that's the only extent to which, let's say, law and economics as a methodology has any kind of relevance. Udita, do you have a follow-up on that? I know this is a very long topic, though. It requires a very separate kind of discussion. But this is my short and sort of a response to you. I hope it makes some sense. But if you have a follow-up question, please go ahead.
No, sir, that satisfies the query. Thank you.
Thank you. All right. Now, okay. So somebody was going to speak, but the hand is not up. So if you have any other query, please go ahead.
Yes, my name is Aditya.
Yeah, Aditya, go ahead, please.
Sir, what is the transaction cost? As in, what does it imply? How does it translate to reality in terms of the fact that transaction cost of Supreme Court adding new expressions is it merely creating uncertainty, or there are any other transaction costs involved?
So
And
the way
secondly,
Ronald Coase, sorry, if I can answer this first question
Fine.
first, and then you
Fine,
can
sir.
ask your second question.
Fine, sir.
So the way Ronald Coase defined was that transaction cost is the cost of entering into any kind of bargain with each other. And he argued that, the term bargain is very broadly understood. For instance, if you're just entering into a contract with each other, search and verification cost would be transaction cost, right? For a society, it becomes more complex because, see, I mean, regardless of whatever Supreme Court might decide, people look up to Supreme Court, right? They are constantly figuring out, is Supreme Court of India somebody who is worried about, or is it an institution which is worried about the text of the Constitution? To give you a very sort of a stark example, for instance, so I don't know where you live, Aditya, but you see, wherever you live, whichever part of the country you live, I'm assuming you live in India, right? Every city in India has these rules about buildings, right? They say that, every city says that, you must leave certain parts of your land to make sure that sunlight can come in, air can come in, wind can come in. Now you will laugh at these kind of rules because every single city, what it also does, it just allows people to violate these building laws, right? Because people don't leave enough sort of place between neighboring areas for sunlight or air to come in. Now the question would be this, because you have asked this question on transaction costs, right? So the guy who follows, or the person, because guy could be seen as not a gender neutral term. Let's say the folks who, let's say, follow laws. Is there a transaction cost? Are they stupid people? Because because they follow these building bylaws, they are leaving some kind of a space for sunlight and air to come in. But the neighbor who violates the law benefits. So think from the neighbor's perspective. So if they know that Supreme Court of India is least bothered about looking at the statute, then it looks like the neighbor is intelligent. No? Then it looks like people who are concerned about following the rules, they are just stupid because, they are suffering because they are following these rules. To take a harder, or let's say another starker example in the pandemic context, let's say people who wear masks and follow physical distancing rules. Like one can think of them as, maybe, they don't really understand what are the full consequences, because there are so many others who are not wearing masks and following physical distancing rules, and there seems to be no consequences. So hopefully, these stark examples, deliberately intended to sort of provoke you, by the way, gives you an indication of what is the meaning of transaction cost. But go ahead with your next question.
What is the transaction cost of robbing the Supreme Court to introduce these new expressions and making it a more fair?
Robbing? What do you mean by robbing?
So essentially, legal positivists argue that Supreme Court must not hold power to add these new expressions. So
no, they don't.
By proposing.
So that's not what exclusive legal positivism is saying. I mean, see, I know people hear about legal positivism, but what you normally read about is what is called inclusive legal positivism. That's H.L.A. Hart and all. This is not what Joseph Raj would say. See, nobody is robbing Supreme Court of India from anything, right? The Supreme Court of India is a creature of the Constitution of India. What Raj would say is that Supreme Court of India just have some kind of a fidelity or fealty towards the text of the Constitution of India, and that's about it. The question of robbing Supreme Court of India from any kind of authority does not arise.
Understood. Thank you. Thank you so much.
Okay, thank you, Aditya. Now there is a privately posed question to me. I'll read it out for benefit of everybody. I had a very basic question. When the statute uses terms like decide on the basis of what is fair and equitable, what do the scholars of law and economics suggest? While ELP would suggest that in such situations, the parliament gives the discretion to formulate rules, do theories like Calderic's efficiency also suggest something for these situations? Excellent question. You see, so when parliament uses the term fair and equitable, what do they mean? I mean, essentially they mean that it has to be coherent with something, right? What should it be coherent with? Like, in terms of text, I suppose firstly it should be coherent with the statute itself. And since the term appears in IBC context, so one can say that, since IBC is a code, it is supposed to be comprehensive. So we are not thinking of a statute outside of the Insolvency and Bankruptcy Code, But what one can also suggest is that maybe one should also look at the Constitution of India, and so long as the tribunal or the courts are interpreting something which coheres with IBC as a code and coheres with Constitution of India, it should be considered to be fair and equitable. Since it's a bit of a philosophical question, therefore my answer is equally philosophical. But if you have any follow-on on that, I'm happy to take them, by the way. So thank you. So fine. Is there any other question that we have? We have 49 participants, which I can see. Few questions over here. We are at 6:06, which is exactly 1 hour. I was a little worried that give. Go ahead. Otherwise, back to you, the organizers.
Sir, I believe there are some questions on the chat asking for some reading material on the subject. So if you could refer everybody to some reading.
Yeah, I think in terms of I can suggest that please look forward to the latest issue of the NLS Business Law Review, because this is going to be published as an article, right?
Yes, this is going to be published as an article. So definitely look for that. If nobody else has any other questions, then we can conclude for today. Thank you so much, sir, for doing this webinar and engaging with all the participants. And I'm sure it was an invaluable and really enriching experience for everybody who was able to attend. And thank you to all the attendees for sticking around and asking insightful questions. And we hope to see you again for any other webinars that the NLS Business Law Review organizes. Thank you, everybody.
Okay, sorry, I got logged off again. So I'm back in. It looks like most participants have gone off.
Yes, so I thanked everybody and said that we will be concluding for today.
Yeah, sure.